technology and human rights related to AI. Today we had a different scenario. We had our Assistant Director General opening the session and then launching one of the most important briefs that we have so far. He's on his way, stuck in another meeting as all of us are. So we're going to start with a panel discussion to start and then we will switch and then go to the launch afterwards. So we're going to start with our esteemed panelists today. We have three distinguished panelists that are joining us, and we're going to start with Ms. Jalak, and I'll introduce each of our speakers as we go ahead to save time. So Ms. Jalak Kakar, Executive Director, Center for Communication Governance at NLU Delhi. Jalak, India's judiciary faces both, first, huge overload in terms of case loads, and at the same time, immense technological opportunities and potential. What are the key ethical or procedural, let's say, safeguards that you think India's courts should prioritize when engaging with AI systems, especially given the diversity and scale of the justice ecosystem?
Thanks for that question, and thanks for organizing this and having me here today. If you look at AI integration into the judiciary, you can broadly say there are two areas it can be integrated. One is in sort of helping streamline administrative load of courts, so whether that's scheduling of cases, or it can be used in more substantive matters like research, translation of documents, or then even decision making. And we've seen a spectrum of applications being developed that help across the cross-section of these tasks. Some have higher risk, such as decision-making. Some have sort of downstream impacts on significant decision-making, like if you're translating documents and if there are errors over there. And then, of course, it may seem that administrative decision-making being taken over by AI may not impact justice, but actually even use of AI and scheduling can impact justice, because AI deciding which case gets listed first, which case is extraneous, can sort of really impact someone's timelines for justice delivery. So I think we need to, of course, categorize AI use in judiciary across various risk categories. And then for each category, we need to think about what is the level of assessment that needs to be undertaken. There are various risk assessment auditing mechanisms that are being established in the AI domain. And there needs to be thought about how those can be translated and used in the judicial context. So I think that's sort of one piece, is auditing and assessments for questions of bias, for questions of transparency, for questions of explainability. The second piece that I think we need to be thinking about is judiciary sits typically in any country on a large trove of data. I know within the Indian judicial ecosystem, as part of the e-committee process, the Supreme Court was really thinking about how do you unlock the value of that data and use it to streamline court processes? How can you give it to stakeholders in the ecosystem, whether it's startups, other public interest stakeholders, researchers, to sort of go through that data and figure out, okay, these are the lessons and this is how we can streamline processes to move through case load quickly. But that also means that you need to have very robust data management practices, data protection principles being applied, because this can in many instances be sensitive and personal data that is getting shared, mixed in with non-personal data. So I think that's the second piece that judiciary needs to think about. I think the third piece, and of course there's so many things, but these are my three, is judiciary doesn't have the expertise to build these things in-house, right? So they're going to rely on third-party vendors. So to engender public trust, I think public procurement has to happen in an open and transparent way. And there needs to be clear guidelines that are set up for what is sort of the assessment of these systems on a regular basis by judiciary external auditors to engender public trust in the use of AI in courts. Because the last thing you want to do is erode public trust in the court system through the integration of AI. So you have to carry the public along with you.
Thank you. Just a quick follow-up. If you can briefly tell us, how can India balance between this AI efficiency, AI-driven efficiency, and constitutional protections, especially in light of this multilingual, multi-constitutional context?
I think that's a great question and something we really need to think deeply about, because I think there's immense pressure to adopt technology because there's so much caseload and it's burgeoning. But I think we have to do it in a cautious way where efficiency doesn't trump due process, rule of law, rights of individuals. When you think about multilingual systems, the thing to think about is that, a lot of these systems are based on things that are built for English context. So how are you going to translate it into use in contexts where you have low resource languages? And then, there aren't necessarily enough data sets for low resource languages, and especially data sets that are primed for use in more legal contexts. So I think that is definitely going to be a journey, because if we want to ensure, as you're saying, the protection of constitutional rights of people and the true delivery of justice, you will need to balance that. I think one piece that we need to really think about is capacity building of judges, and I know that's something UNESCO has focused on heavily over the last, several years, in fact, the last close to a decade, under its AI and rule of law program at NLU Delhi, at CCG. We were part of the first MOOC that was designed for judges, and I think you train thousands of judges around the world. We are on the technical committee for the second MOOC that you all are designing for judges with Oxford University. And we've also done trainings for South Asian judges at NLU Delhi on AI and rule of law. I think bringing awareness to judges on that AI is not a neutral technology, that it's a socio-technical technology, and that it's not going to make neutral decisions. If it's trained on biased data sets, it's going to give you biased output. And building that awareness of where AI is useful but what its limitations and challenges can be is extremely important. I was at this conference organized by the Supreme Court of India with the Supreme Court of Singapore, and they brought together a lot of Supreme Court judges, a lot of senior High Court judges. This was a few years back, and what was very telling to me during that conference is, these are extremely distinguished jurists, the top legal minds of our country, right? People who've been in this space for 30, 40, 50 sort of years. And they had very, very fundamental questions on AI, and they were really grappling with, okay, where is it appropriate to use these systems and where is it not? And I think we need to bridge that divide where people working on AI and technology need to sort of sit in the room with a public interest lens. People working on it with a public interest lens need to sit in the room and really break down what are the risks we're seeing, what's appropriate, because so that they don't need to reinvent the wheel. And I think UNESCO is playing a great role in bridging that divide.
Thank you. Very interesting points here. I would like to go now, because you mentioned a very important component, which is the capacity building. But before we go to our next speaker, I'd like to introduce Professor Sri Krishna Deva Rao, Vice Chancellor for Nalsar University of Law. And my question to you is exactly what Jalak was saying. From an academic perspective, how should legal education for lawyers and for judges find some sort of adaptation to prepare judges for this AI-driven justice environment? What skills, what ethical, perhaps, reflections should be also included?
Yeah. Just now, Jalak mentioned about, I'll start with the multilingualism, what she said, and then I'll come back to how the legal academia has to respond to is a major new age thinking as a relearning the law. But multilingual is an important, which is India is a land of several languages and several dialects, and of course the Anglo-Saxon legal system was able to reach out only to the communities, those who are privileged, and this is a challenge before the legal education. I think that may take another 10 or 20 years. How do we really, the massive justice gap can be at least temporarily answered once the legal education moves into more and more into the language teaching in the mother tongues and other. That's where the AI can really help, but that requires not just use of the AI translation into the several languages, but we require several experts in the legal academia, those who can understand, journalists, and the several things. But the legal academia, or I would look at when national law universities were started in India in 1980s, we used to say what we need is a professionally competent, socially relevant, and technically sound. That's what the slogan which started is aim and objective. Now we will say in addition to this, we need technologically literate, technologically equipped lawyers, entire legal fraternity. So as a law teacher, always we look at how the new curriculum has to be developed. But when the curriculum is developed, we need to have the entire participation of the legal fraternity, the law firms, IT companies, all have to come together and to see how they can create a more challenging, more engaging curriculum and the pedagogy. For instance, we teach what we call is in the legal academia bread and butter courses, constitutional law, corporate law, criminal law, and several other various areas, property and several other. But now we need to think about introducing maybe second year onwards a specialized honors in the law technology with focus on the artificial intelligence. As someone who has been associated with the legal aid movement in India over 3 decades and the paralegal movement in India, I would say that it requires several levels of first legal literacy. How the AI can help in the massive legal literacy which required in several of the languages and using a new pedagogical method. Second is community dispute resolution. How the online dispute resolution with the participation of both lawyers, judges and the legal academia must help. In fact, generally in the legal education, sometimes we drew parallels to the medical education. Because like a medical education, a medical college in India will not be given a permission unless you have a teaching hospital. Why don't we have a teaching course? AI, law and technology provides that an opportunity. For a consumer dispute, I wanted to settle because the public have a confidence in legal academia rather than any of the legal fraternity. Simple family disputes, I wanted to resolve. Land disputes, because that's a major challenge of massive backlogs. We can start where legal academia takes the major responsibility and duty, not only creating a new curriculum and pedagogical tools and methods, where 40% in the classroom, 60% in the technological companies. That's a clinical legal education, clinical pedagogy can be used. Second, we need to train, orient the legal fraternity, starting from the law students first, and then the lawyers and judges and others. So I'll stop here. And I think I have taken sufficient time. Yeah.
Not at all. Thank you very much for your very relevant contribution, because you're right. Everything that we do has to have this multi-stakeholder approach. It cannot be done by only one side only, not only judicial institutes, but also across the board. And allow me to welcome our Assistant Director General, Dr. Tawfiq Jalassi, for joining us. We're going to come to you. We have pushed the launch actually to the end of the session instead of the beginning. We have one more speaker here, Mr. Arghya Bhattacharya, and I'm really sorry about my pronunciation if I mispronounce any of the names, co-founder and CTO of Adalat AI. So Arghya, as CTO of Adalat AI, you are powering courtrooms across India with tools like real-time transcription and case management. What real-world applications are you seeing that reduce barriers, especially for marginalized or rural communities, while aligning with principles of fairness, transparency, and non-discrimination?
Yeah, firstly, thank you so much for having me here. I think there's 2 tracks to how AI is being used to sort of improve access to justice. The first track is more direct, which is directly with the communities. And I think over there, a big part of the problem in the global south is, people have no idea of getting information about their cases. They have no idea what's going on with their cases. It's extremely difficult to navigate archaic government websites to find out, where is my case? What's the judgment? What do I have to do next? There are complex jargons that lawyers love to use, like interlocutory order and res judicata, which common citizens just don't understand, right? And so I think one big use case of AI is to be able to make sure that communities are able to access this information easily, right? And to that extent, at Adalat AI, we recently launched a WhatsApp chatbot where you can have a conversation in any language that you speak, not just English, and you can give your name, maybe your PIN code, and find out if you have a case, what's the next action item to take. And so that's more of the direct sort of access to justice solution. The second track is more around the indirect access to justice sort of solution, which is to improve capacity of courts. Now, when we talk about improving capacity of courts, just to paint a picture, because now, along with my co-founder, who's a lawyer, I've been down deep in the trenches. Courts in India are severely broken. There's paper everywhere. One of the use cases is that, judges write by hand. So if we were all in a courtroom and, I asked, as a lawyer, I asked a witness, where were you on the night of 21st April? The judge would stop us there, write this by hand, and then the next thing would be dictated. Now, as you can imagine, this becomes a serious bottleneck to court proceedings moving fast. And to that extent, we've built AI transcription solutions so that you don't have to write things by hand. You can just go about your witness deposition, and then you get a transcript of the same. By virtue of the process itself, everything is verified on spot. What we are seeing is that solutions like this, which are simple, that don't go into sort of being an AI judge or suggesting how to make a judgment, are able to improve productivity at a daily and weekly level by 2 to 3x, which at scale could reduce case resolution timelines by 30 to 50%, depending on case stage and type, right? And so I think the big point that I'm trying to drive home is that even apart from the frontier of technology, even apart from just being able to predict cases or being able to, sort of summarize or translate cases, there are so many other very basic tasks that AI could help with. Transcription is something that has been there for about 20 years now, speech to text, that is, right? And so there are a lot of technologies that are safe to use today, and I think we should really work towards making sure that our judiciary has access to those, and that's kind of what Adalat AI works on. We're in 20% of India's courts today, and that's kind of where we've observed this statistic. Now, coming to this last part of your question, which is, how do you make this fair, trustworthy, and make sure that this doesn't discriminate? I think that's the hard part about AI. When it comes to being fair, I think given the current state of technology, fairness means making sure that you're only grounded to information that's available and not being suggestive. Not giving any sort of judicial advice. Let's say if you're building a WhatsApp chatbot for communities to find out about information about their cases, AI systems cannot give advice today. That's not safe at all. Those things have not been audited yet. We have no benchmarks for doing that. And so I think that's more around the faithfulness angle. In terms of trust, I think what needs to happen is AI systems need to acknowledge when they don't know something. That's something that the entire AI space is working towards, making sure that we can get our models to say no more often. And I think that's what it means to be trustworthy right now. And in terms of making sure that they don't discriminate, I think the biggest thing that AI models need to do is make sure they account for the linguistic diversity. And that's the largest problem that we have in the country, and Adalat AI and a lot of other players in the ecosystem are working to make sure that every language and every dialect is covered, because just giving information is English is not good enough. So I think these are some of the challenges towards fairness, trust, and making sure AI systems don't discriminate, and possible solutions as well.
Thank you. Thank you very much. It's interesting to hear the different perspectives, but it's also interesting to know that while AI is global, we always have to look at the context. Implementation in all countries and regions should not be the same. India has this diversity and multilingualism that perhaps is not there in many countries. So my next question is for you, Dr. Jalasi. We've heard from different perspectives. From UNESCO's perspective, what would you say would be the urgent next steps for member states to actually institutionalize this AI training for justice across the board? But also, more importantly, how this could translate into real judicial independence and accountability in practice.
Thank you, Mali. Good afternoon, everybody, and sorry for arriving late. I was speaking at another session. So obviously, I'm trying to gather what was said from the previous speakers. Well, as you know, UNESCO, which this year celebrated its 80th anniversary, had as a constitutional mission to build peace in the minds of men and women. Justice is a foundation for peace, as is education, culture, science, communication, and information. So for us, today, when we look at the result of a survey we conducted in 2023, it revealed that 90% of judiciary professionals use AI without any prior training nor guidelines. This is frightening. 90% of them use AI, but they never had any guidelines nor any training. And we know that some of these AI systems unfortunately use data sets that carry some biases, whether it is about gender, ethnicity, language, geography. So what I'm saying is that these AI systems could, and in some cases that we have documented, did misguide, misinform the judiciary. So needless to say that the outcome would be rather negative. And in this case, AI will not be a force for good, but a force for risk and even for harm. So UNESCO developed training, including massive open online courses on AI and the rule of law. And we have trained to date more than 10,000 judges, prosecutors in a number of countries around the world for the proper use of AI. So yes, of course, AI can help on a number of dimensions. It can reduce the time to process judicial cases. It can reduce the cost of it. It could help with maybe past cases. As you know, in AI, there is one field called case-based reasoning. It could bring to the fore some past cases and how they were dealt with. However, the integrity of justice cannot be automated. And that we should keep in mind. So AI and AI systems in courts and tribunals as a help, as a support system to the judiciary professionals, but not as a replacement for them. And this has been a guiding line in the work of UNESCO, which has been anchored, as you know, Mali, in the respect of human rights, in respect of human dignity, in ethics, in equity. So we have to keep these values and these principles as guiding our work as far as artificial intelligence and the judiciary. And finally, I would say, when I mention these human rights, human dignity, and the like, you may know that for now 13 years, UNESCO has trained more than 36,000 judges and prosecutors in 160 countries on freedom of expression, safety of journalists, because quite often when there is a legal case against a media professional, the judge and the prosecutor have to process that. So we want to bring the awareness or the knowledge up to date of the judiciary regarding international standards on freedom of expression and on safety of journalists and on media, because you believe that freedom of expression is a human right that enables other human rights and should be taken as a foundation for what follows as far as our work on AI and the judiciary.
Thank you, ADG. I have a follow-up question. So, as we said, international standards are non-negotiable. Human rights are non-negotiable. But there are sometimes there are certain contexts, as we said, the multilingualism, the diversity in India and others, that requires some adaptation of the tools that UNESCO and other organizations offer. So how do you see, what would UNESCO be able to do with India's leadership in this AI adoption? How can we support these regional adaptations?
You are absolutely right. It's not one size fits all. UNESCO has to work on a global scale because UNESCO has 194 member states. It's the world. So, of course, what we provide in terms of guidelines, in terms of framework, in terms of the UNESCO recommendation on the ethics of AI, which was adopted in 2021. That's 2 solid years before the advent of generative AI and the advent of ChatGPT. We had the work on this recommendation started in 2018, and it was approved in 2021 by all 194 member states, calling for an ethical, responsible use of AI. So what I'm saying is our work is global, like the guidelines for the use of AI systems in tribunals and courts. These are global guidelines, but of course they need to be contextualized. So of course taken into account by the judiciary in different countries, regions around the world, contextualize them, taking into account the specificities of that country, cultural, legal, socioeconomic specificities. And that's why I'm saying it's not one size fits all. But at least national judiciary systems and courts and tribunals have a good blueprint on which to build. Take the UNESCO work instead of starting from scratch, and then, of course, adapt it, not adopted as is, but adapted to the local or the national context.
Well, since we're talking about guidelines and tools, I think this is a moment for us to launch here, in your presence, our new policy brief related exactly to the same topic. So, Mr. Jalassi, I invite you to the podium, perhaps, and you could maybe share with us the latest policy brief, and then we can take some questions from the audience. Sure. Or if you can speak here as well.
Do we have the document? We don't have a copy. I don't have a copy of the document, but since you know what AI, it's a virtual document. It exists, but for now it is in a digital forum, not in a paper forum. So we are delighted having authored, developed this policy brief. We believe, again, that it is useful resource, and I say it's a resource that, of course, member states and the judiciary may want to use or not. This is the work of UNESCO. I mean, part of our work is advocacy, but advocacy based on evidence-based work. And we believe that advocacy could lead to national policies or to regulation or to implementation. And we do help as well with that. It's not only we do research, we publish, we do advocacy, but we help member states at their request develop national policies and implement them. In addition to our normative work, when I mention the UNESCO recommendation on the ethics of AI, it's not a convention, because otherwise the convention would be legally binding. We don't make it legally binding, but a recommendation to say this is a set of principles that was developed by more than 100 international experts. Then it was endorsed or approved by all our 194 member states. We believe it has a value for each country around the world, but it's up to the national authorities, the professional communities, to decide to what extent they want to adapt and use these guidelines or this policy brief which Mali mentioned. You are looking for it, I think.
Thank you.
Online.
I actually have it and a QR code for people to
Yes,
scan.
please.
And in the meantime, I can coordinate the Q's and A's, perhaps,
Sure.
from where I stand while I do that. We do have some time for Q's and A's, and I think it is as important for you to be able to approach the speakers and have questions than the speakers just having a one-sided discussion. So, yes, we can start taking questions. I don't know if we have a microphone. If someone can help us give to the speakers. We have the first, the audience. We have one question there. Ashita, can you help us with please, the questions? The microphone. I will.
Hello. Yeah. So my question is generally to the panel here. What is the so basically we were hearing. I heard all the panelists and everybody gave their views on the reliance of AI in making decisions and judgments. Do you think going forward and in future, what will be the liability of AI? how can we make AI liable, in making judgments as well? Because as Sir said rightly, a lot of judges are relying on AI and making decisions. And so just wanted to ask you, there'll be a code set up for making AI liable or not?
I think Sir just referred to the fact that, a very high number of judges are using AI without any kind of guidance being given to them in a national context. So I think before we get to liability, we perhaps need to ensure that guidelines are developed domestically around AI use by judges. What it's appropriate to use it for, what it's not appropriate to use it for, where you are using it, what kind of safeguards, process checks need to be in place around its use. When courts are acquiring AI technology, whether it's for translation, transcription, administrative management, research purposes, what kind of vetting, auditing, assessments of the system is being done at the point of acquisition of this technology, but also post-deployment assessments and audits that are being conducted. How open and transparent is public procurement? And then what is the kind of transparency that is remaining? So first you have to put into place these safeguards, right? I think liability then becomes the next layer. I think at this point, adoption of AI in courts is being used as a tool for judges rather than direct impact where it's directly impacting citizen rights. I mean, there have been instances of Compass and HART and Victor, other technologies which were deployed in jurisdictions like the US, Brazil, the UK, which didn't, had their own sort of challenges. I think people are more cognizant of it now. So I think decision making, I would say, is largely still vested in judges. So I'm not sure where that liability comes in. But I think overarchingly, governments are increasingly thinking about liability of AI systems more generally, right? Not specific to AI use in judiciary, but I think more generally. And I think that is still an evolving conversation. There's a lot of thinking going into, from strict liability frameworks that have been developed, tort liability frameworks that have been developed across, the last, hundreds of years, what learnings can be drawn in the context of AI liability. There's been a lot of conversation around, is there something to learn from intermediary liability principles that have been imposed on internet platforms, social media platforms, the due diligence obligations that are imposed on them. So what learnings can we take from all these spaces and then translate them appropriately into the context of AI? So I think there's still, I don't think there's quite consensus on what liability looks like, but there's definitely ongoing conversations on this issue.
Just to supplement Jalak, yesterday, I think some of you have read Supreme Court, Chief Justice of India mentioned about some of these. And what we could see is that it is the lawyers, those who use and through their arguments, they mention with the use of the artificial intelligence and some of the, even in Kerala, we can see Bangalore, there's an income tax tribunal. When the judgment came, they realized that the lawyer who mentioned about this case in the income tax tribunal, the case does not exist. The principle does not exist. So it depends more on what we are mentioning about UNESCO. The toolkit will help, and also individual, even the Supreme Court and other high courts, the Department of Justice has to come out with a comprehensive guidelines, but till that time it's an individual judge, he has to use. Of course, we can see that some instances are coming up where the judges are using the AI for the research and the judgment. But all of us, what we have seen in the panel discussion, we must remember that the legal representation will remain. Lawyer cannot be replaced by AI. Teacher cannot be replaced by AI and judges cannot be replaced by AI. Yeah.
Thank you very much. Well, I see we
Thank
have
you.
a number of questions, and I'm glad we have the time. Okay, let's see, if there's a lady, let's do, no? Not interested? Okay, we'll take second question and third question here. Okay, we'll take her first and then we'll come to you. Sorry, thank you.
Yes. So we are talking a lot about AI for law, but what about law for AI? So when we are talking about, we are having a lot of frameworks and in education, in communication, in jurisdiction and everything. But what about a common framework or guideline or a policy to use AI or to use the data of AI that has been produced or developed, or a common understanding to the audience that what is law for AI can be? What are the benchmark for using the AI or any kind of AI tool? What is right or what is wrong? That is what I wanted to know from any of you, if you would like to.
Thank you. Maybe we can take two more questions and then there are similarities. And if you also want to address it to a particular speaker, please do so, unless you want to address it to the entire panel.
My question is for Arghya. You mentioned two specific streams where AI is sort of broadly being looked at as a potential use case. Do you also see a potential need or opportunity for point solutions, for example, QC of critical documents, etc., which have a significant bearing on how an individual case sort of moves forward, the delay, the outcome as well? Could be a POXO-related charge sheet, could be a domestic abuse-related charge sheet, coming from a very narrow perspective, but QC-related sort of opportunities as well. Thank you.
Yeah, no, that's a great question. I think that's the territory where I advise AI practitioners and companies building to stay away from. And just to tie that up with the previous point of training judges in the context of India, we have a thing called the Adalat AI Academy, which in fact the curriculum of which we've been building in partnership with UNESCO. As part of that, we've done a lot of trainings with judges in India. A lot of them don't know how to update their browsers. Right? They don't know how to update their Chrome browsers yet. And so the first thing is for them to understand that if they use AI outputs, they're liable today, right? And to that extent, giving these tools in these settings to people who don't have the knowledge yet can be extremely dangerous. So I can tell you a few examples where AI could help even with sensitive matters. One is perhaps transcription, because again it's very sort of embedded technology right now. You're just saying and it's writing what it is. The second is you have these long documents that you have to always go through, and this is a common problem for lawyers and judges. AI can be used to ask questions and not get answers, but the AI then scrolling and taking you to the right part of the document, right? And often the problem becomes that you just have to scroll through thousands and thousands of pages. And so if you think about it, a small trick makes AI a lot more auditable in this case, as opposed to you asking a question and then it generating a huge answer where you could have fake cases being generated as well, right? And so it's really AI plus how you design the user interface that's going to do it. But generally, I would avoid using generative AI in sensitive cases.
So my question is from a team representative of NLU Delhi and Adalat AI. Considering the UNESCO mandate on linguistic rights, what are the challenges that the AI can cater in an aspect of English only mandate through Article 348 of High Court and Supreme Court, and how multilinguistic criteria and can be integrated in a judicial system of India?
Yeah.
Can we take another second
Yes.
question and then we can answer both?
My question is actually twofold. My question is actually twofold. The first part would be, a lot was said on guidelines on use of AI, but how do we ascertain guidelines which are indicative in any way, in all ways actually, are being used or are being applied to in the right way in all the existing matters, because they are indicative for us. So for us, how do we ensure that the steps that are being taught or that are being told is being adhered to or not? Because there is no way to reverse engineer this and know if a particular case is affected by those guidelines not being in place or not being or there in place or not. The second part to that would be, how would I know if my case, because for example, as Sir rightly gave that example, as a case which didn't exist was cited and an order was passed on that. So how would I know that my case is not being affected by a bias or by some case which was not in existing, which is not in existence, but the opposite side has argued that case? So
Thank you. So we have two questions, one also twofold. Would you like to start first? You were already starting to respond to the first
I can start with the question on the multilingual aspect. So it's a very hard problem. It's important that we acknowledge that we have many dialects. The way that people speak, let's say, English in Kerala is very different from the way that people speak English in Delhi, let alone the fact that we have thousands of dialects. So there is a certain way in which you can build translation systems that can actually address this. I can maybe give you an example of some of the efforts that are going on by the government, by Supreme Court, and also by Adalat AI, which is to build these systems using expert preferences. What I mean by that is, let's say there is a legal document that needs to be translated to, let's say, a local language to make sure that it's accessible. What we are doing is we actually give copies from humans and a lot of different AIs to lawyers. And then we ask them to choose which one they like the most, right? And an AI solution is only allowed once it reaches a point where 80% of the responses are from AI and they're being preferred by humans. So that's one of the things that we've done in Karnataka, and some of the translation systems in Karnataka are run by Adalat AI. And we've seen that humans actually prefer AI output 80 to 90% of the times, and these are legal professionals. These are not just any annotators. So that's one very important thing, which is to make sure that the expert human is in the loop, right? And I think the second challenge overall is it's going to take time. It's important to understand that AI systems are not just going to do it overnight, and so we still have to build capacity for translators in the state, and which is quite lagging right now. Yeah.
And we have the second question that was here. Anyone would like to respond to the other question that we had?
I think the question was around,
Can you maybe quickly sum it up in a couple of seconds?
guidelines being indicative. So how do we establish the fact that these are being adhered to, and the steps that are taught or that are told are being applied in that order? For example, if you skip one step, you may not go in the right order to the steps to the next step. And the other part was that how do I know that my case is not being affected by AI or the bias involved in that? Because any way to reverse engineer it.
Thanks for summing that up. I think within the judicial system, there will have to be, you have Office for Data Protection Officers, right? The Office of Data Protection is being set up in many courts. Similarly, either within that office or a separate office, depending on different contexts, different judiciaries may choose to do it differently. You will have to have sort of an arm that is set up within the court system whose function is to oversee, enforce, and sort of look out for patterns and challenges that sort of may be emerging at any given point in time. In terms of how do you know that your case is not being affected, I think lawyers and participants in the judicial system have to be vigilant and point to challenges that emerge, surface challenges that emerge, and so that patterns of harm get visibilized within the judicial system, and they can be flagged, right? So where there are harmful instances or challenges arising, there needs to be a feedback loop into the judiciary, a grievance redressal mechanism, sort of where it's flagged that this AI use is being problematic. But a lot of AI use and its harmful impact may be invisibilized, where you do not realize that this decision is being made based on AI systems, which is why you need third-party audits, assessments, and other practices which may not pick it up at an individual level, but at a more sort of meta level, it will be able to identify that these are the challenges in the deployment of this system, and these changes and tweaks need to be made to the system to ensure that it is non-discriminatory, that it is maintaining privacy, that it's not implicating freedom of speech and expression norms. But I'll defer to Dr. Krishna Deva Rao over here, since he has decades of experience in these kind of questions.
Yes. Just 90s, we were looking at in the legal academy, particularly in India, court managers and case management. And the Supreme Court has come out with each district they have appointed a court manager who is a management graduate. They did not work. But now we need, with the AI, we need a technologist at the each, not one person, a group of persons at the district courts, data protection, data analysis, helping the judge in the research, summary, translation, so many things. But as we all have agreed that AI will not substitute for a judge or a teacher or a lawyer. So, but some of these safeguards, it has to be built up. I think that's where it's a concerted effort has to be made. Everybody and technology, particularly the IT companies. In fact, when we say that, I am passionate that even the law students must be trained to develop a software development. An engineer is developing, maybe the engineer may not understand the technicalities of a law or a court and other. So we need to think about now how software development of whether this is online dispute resolution, judicial research, preventing the bias, discrimination, preservation of constitutional values, equality, all this, only a law student, but that requires as a major challenge of rethinking. Thank you. Okay,
Mr. ADG, would you like to add something?
Just some final words.
Maybe before the final words, I see some people here wanting to ask questions. Look, if you promise your question will be straight to the point, fast, we'll take one lady, one here, and one here. He asked first, but you're welcome to ask later. 2 questions? Okay, so can we take one here and one from there, and then you can talk to the speakers?
Hi, my name is Abhishek. And I'm a podcast host doing podcasts with judges of Supreme Court and High Courts mostly. So I have met so many judges in my time, and 99% are reluctant to do work with AI, and I do not blame them at all because of the facts which you have just mentioned, that AI is still hallucinating and all. So how do we make them comfortable? How do we make sure that their judgments, in case they are relying on AI or some lawyer is relying on AI, then they are not misleading?
Okay. We'll take the second question, and then we'll go there for the last question.
Hi, panelists. Thank you for such an insightful talk. My question to you is, how do you protect the creativity? So we see in India a lot of judgments, and everything is based on emotions. How do you protect creativity? That is one question. Secondly, the older generation is still on, they are more towards documents and commentaries that are available. However, the new generation that is coming, they are more tech-based. And for them, for me, experience matters over tech. And how do you create a distinction, because it will also affect the employment and the employment in the legal fraternity. How do you protect that?
Thank you. We go there.
Yeah, thank you. My name is Hoffmeister.
Can you turn it on?
Is it on? No? There we go. Okay, last question. I'm Hoffmeister with the German Ministry for Digitalization, and towards the end, one provocative question. Don't you think that maybe the use of AI for judges by judges should become mandatory in the future? The legal system is based on trust and on acceptance. And if we see AI being more accurate in the future, the judgments being more precise in the future, and comparing one judgment which is extremely precise with the help of AI, and one court deciding not so precise, the trust of society goes down. So I just provocatively ask, should we not make use of AI by judges mandatory in the near future?
Thank you. So we have 3 questions, less than 5 minutes, and Mr. Julasi would like to close, and I would like to tell you something. So I don't know if each of you would like to answer very briefly, straight to the point, what each of these 3 questions.
I think it requires a judicial education where I think some of the questions were raised. I think very challenging. How to simple English writing, and then how AI can supplement, and maybe a judge may mention that he used the AI. So that safety, skepticism, and using that, preserving the essence of the judgment, how it is to be right. I know it's difficult to write in a simple language within a small paragraphs. Maybe a 5 pages a judgment, it's a difficult. Some of them, they used to say, they refer to the Privy Council, some of the outstanding judgments.
Yeah, to answer your question more directly, AI is actually mandated in a lot of courts in India. So for example, there's a state called Kerala, and Adalat AI is actually mandatory in every courtroom in Kerala. You cannot record witness depositions by hand. You need to do it using Adalat AI transcription, right? And to that extent, before any such mandate kicks in for other use cases like judgment writing, I think what's important is to do a serious economic impact evaluation. It's important to see that the impact is measurable, and it's also important to see that across the board, generally you see better and fairer justice, and only then can AI be mandated. As long as that infrastructure can be developed, I don't see a harm in mandating AI.
Thank you. Have we answered all the questions? We had the old generation versus young generation. Anyone has a message to say?
I guess calculators came in, we didn't get bad at math, and so we'll have to figure out very similar. Yeah, maybe we did, but we're still moving on in terms of doing more innovation. We are still building more, right? And so we'll have to figure out something similar. I think the educational curriculum will have to change to account for AI as the new calculator as well.
But all generations must learn AI.
Thank you. Dr. Julasi would like to say a few words, just to thank you for coming, but I just want to say if you can scan this for the publication if you haven't already. Okay, done. 1 second. And then there's the other one where you have all the resources about all the guidelines that UNESCO has and can offer. So 1, 2, here. And Dr. Julasi, I give you the floor. You can scan this code for all the different material.
Thank you, Mali. The mission of UNESCO has 5 C's in it. I think our meeting here first is to convene, to converse, to comprehend, to commit, to collaborate. And there is a 6th C, which is capacity building. And I think what you mentioned here, our work on AI and the rule of law, our guidelines for the use of AI systems in courts and tribunals, the AI essentials for judges, which we officially launched here. These are just examples. These are 3 key capacity building means. We have to ensure that together AI remains aligned with the human rights, with the rule of law, because as I said earlier, the integrity of justice must not be automated, and we have to ensure that AI strengthens, not sidelines, judicial independence, fairness, due diligence, and the integrity of the judicial process. On the last exchange between some questions and the panelists, when we said, what can we do with AI? I think, generally speaking, we cannot stop technological advances. We cannot. But we need to provide the framework. We need to provide some sort of an overarching regulation. It's not in a regulation that hinders creativity and innovation, because the lady had a question about that. It's not either or. We need to have some overarching guidelines, principles, for using AI responsibly, ethically, and make it a force for good.
Thank you very much. Thank you all for joining. The message was clear. AI can change maybe the way justice operates, but not what it stands for. Thank you very much. Have a wonderful summit.